All right, we're going to start in 1 minute, everybody. Thank you for coming out tonight. I appreciate it on this riveting topic. People will be given comp time. There's free food. What else can I do, right? You get nothing. I'm going to pass, at the end of the presentation, I'm going to pass around the sign-in sheet. Please make sure you sign it. You have it going around already? Okay. I was going to wait till the end so nobody boots, but. You good, Fred?
Okay. Feel free to finish getting your food, but I thought I might as well start since we're that time. So I'd also like to thank you for coming out. I know there's better things to do on a Monday night, but my name's Brian Riley. I'm a partner with KP Law, your town council firm. And one of the things that we do a lot is go around to our client towns and give these seminars at no charge to the clients. All kinds of different topics, but kind of the three big ones that it's important for pretty much everybody to at least have a passing knowledge of are the conflict law, the open meeting law, and the public records law. I'm only going to deal with conflict of interest tonight. A little too much to do all at the same time. And okay, I will just start in. So this is a basic legal disclaimer, but I will say that I'm going to be talking about the conflict law, which is Chapter 268A of the general laws, as interpreted and enforced by the State Ethics Commission. And so I'm going to be, fairly broad brush, going over what the statute says and kind of the wrinkles that the Ethics Commission has in interpreting it. I'm happy to take questions as you come. I'll probably repeat them so they get picked up on the microphone. I prefer getting questions as we go rather than holding them to the end, because then we both can't quite remember what happened before. I'm not here. Obviously, the conflict law has a lot of serious provisions, a lot of prohibitions and restrictions. But I'm not here to get anybody in trouble. I don't want to play gotcha with any of these questions. But I'm happy if you have a question as we go, or you don't understand something I said, to try and clarify that as we go through. Hopefully, my voice will hold out. I'm coming off of a cold. But so the conflict of interest law, as I said, Chapter 268A, and then the Ethics Commission's regulations are here in the CMRs. They have they're a pretty extensive list right now, and I will touch on a couple of them. So the law has about 29, I think, sections, but some of them are specific to state employees, some are specific to county employees, not as many counties left as there used to be. But there's still some, and so I'm obviously going to focus on the one for municipal employees, and these are Section 3 restrictions on your ability to get a gift, or want somebody to give you something that's related to your office, and then 17, 18, and 19 are the three, and 20 are the ones I deal with the most, and then the code of conduct ones I'll touch on at the end as well. So 268A has a bunch of definitions in it. The first one is municipal employee. Believe it or not, even if you're on a volunteer board that meets once a month and you obviously don't get paid for it, you are still a municipal employee under this law. That term employee is different from every other connotation of the term where you're hired and paid to do things. This just covers anybody who's doing anything for the town for the most part. As you can see, holding any kind of office or position, employment, elected offices, appointed positions, by contract of hire, with or without compensation, full, regular, part-time, seasonal, consultants. It can even apply to, let's say, a civil engineer who gets hired by the planning board to do a peer review of a particular application. Most of the time, that engineer is going to be covered by this law. He's going to be considered a municipal employee while that is going on. So it really has a pretty broad reach. The only two things that the definition exempts are elected members of town meeting. I don't believe Dudley has that. Some bigger towns have representative town meetings, or an elected charter commission. So as you can see, it's just very broad, and that's why it's important, no matter what your position is, to have have a little knowledge about it, and that's why I'm here. Special municipal employee. This is a designation that applies to certain positions, and there's a couple that are designated by a general law itself, like housing or redevelopment authority members. The statute says they're special municipal employees. Otherwise, it's a position that is either unpaid, like a lot of the town boards, or a part-time position that that is compensated for up to 800 hours per year or less, so that's about 15 hours a week. And there are two sections, section 17 and 20, which I'll talk about. They have sort of additional exemptions, makes it a little easier to do things and not get tripped up by those two sections. That's the only other relevance to being a special municipal employee. I forgot to mention, I think most of you have them now. I had a few handouts. One was just the copy of these slides. One of them is about acting as an agent. That's section 17, which I'll cover. It's an important one. It has a lot of things that can trip you up if you're not aware of them. And another one had to do with if you are acting on something and it's either you're in a butter to that property or otherwise, close to it. The Ethics Commission says we might deem that you have a financial interest in that matter, even though it may not occur to you that you do. So I'll touch on that a little bit. It's one that comes up more often than you might think. So some other definitions. Section 19, which says don't act on anything in which you have a financial interest or your immediate family has a financial interest. And that includes yourself, the town employee or board member, your spouse, and then each of you and your spouse's parents, children, brothers, and sisters. So this can work out a little odd sometimes, like a brother-in-law. If I'm the town official, my wife's brother is clearly covered by this immediate family definition, and he's my brother-in-law. However, my sister, who is covered, her husband, also my brother-in-law, is not under this definition. So section 19 might work a little less stringently for that person. So this definition is important. And some of these sections talk about that you're prohibited from doing something unless you make a disclosure. Sometimes that has to be approved by somebody. But that's just a writing where you lay out the facts, what you're being asked to do, what section of the conflict law this might trigger. And as long as you have it disclosed, that a lot of times can cover you from getting in trouble down the road. Typically, disclosures are either filed with your appointing authority if you have an appointed position. Elected officials file them with the town clerk's office. And the Ethics Commission has many disclosure forms that you can just print out and fill out if you need to. So then into the substantive sections. Section 3 says that a municipal employee may not accept a gift of substantial value. It doesn't tell you in the statute, but the Ethics Commission says that's $50 or more. If it's given for or because of any official act performed or to be performed under your official responsibility. And so that's about all that the statute itself says. The Ethics Commission has adopted some regulations to give a little more detail. Some gifts, basically gifts that are worth more than $50 and it's being offered to you because of your town office, for the most part, those are prohibited. Certain gifts don't fall under here, and the regulations spell that out. Somebody wants to give you a birthday present. Obviously, that's not because you're a town official. It's because it's your birthday. So that's not a problem. Town employee phone discount plan is in there because back when I started doing this, the Ethics Commission said, well, if Verizon comes in and says, well, we want to give certain employees a discount because we appreciate what they do, or we've had some health clubs who say, we want to give discounted memberships to the police and fire departments. Ethics Commission say, well, it's a gift and you're getting it because of your official position, so no can do. They have kind of put some wrinkles on that, and with this, for example, the employee phone discount plan or a health club thing, Ethics says, well, if it's being offered to all municipal employees the same, and if it's sort of an industry standard, in other words, Verizon or the health club might do the same thing for private corporations trying to get members as well. If it meets those two criteria, they will say not a violation of Section 3. So,
Right.
Yes?
Question. What if that benefit is being offered in the form of a grant to a specific class of employee or a department of employee? Competitive grant.
If it's, no, that's an interesting question. A grant, I mean, typically, I think grants under some sort of grant agreement, it's probably not so much a personal benefit. I mean, I'm not sure what if it's a grant going to the, planning department to do something, everything about 268A is really aimed at the individual. So is this an individual receiving something personally because of their office? That's often not okay. But a grant, I think in the most case, the grant's probably more for the town rather than a particular person. Does that make sense?
Yep.
Okay. For other gifts, if it's related to your office and it's being offered to you because of your office or some action you may have taken, and it's less than $50, in general, a disclosure, a written disclosure, and it's okay. You either, again, file it with your appointing authority or the town clerk. Just as an example, let's say a developer has some major project and they keep coming in, and someone in the building department has been very helpful to them, and they just want to say, oh, thank you so much, really appreciate it. Well, if they give you something, a gift certificate or a bottle of wine or something that's worth less than $50, you are required to file a written disclosure that you got that, but then you can accept it. If it's more than $50, in general, it's just prohibited. There are a bunch of things in this CMR section, which I won't go through, but they, again, Ethics Commission's kind of carved out some exceptions. In your official capacity, let's say you're a department head and some company wants to have you travel to their factory so you can see some kind of a piece of equipment you might be looking for. If it's for a legitimate job-related public purpose, Ethics says file a disclosure, but that can be okay. And a training event or a conference, town clerks have a conference every year. They may get a little, benefit from that, but again, it serves a legitimate public purpose, so very often that and refreshments and whatnot. If it's within the scope of your office and serving a public purpose, file a disclosure and you should be okay. All right, section 17. So this has sort of two pieces to it. A municipal employee is not supposed to receive compensation from anyone other than the town with regard to a particular matter in which the town is a party or the town has a direct and substantial interest. And the second part is you're not supposed to act as an agent or attorney for anyone other than the town with regard to that kind of matter. So is it to say the purpose is to avoid you, doing something on your private benefit and or in your private capacity that's going to sort of have a inherent conflict with your public office. If you hold a public office, the thrust of the conflict law is that should be your focus and not using your office to kind of get some sort of benefit and kind of get tangled up there. This is one where being a special municipal employee applies less restrictively. Less restrictively. For example, if you hold a town office, you sit on the zoning board or something, and you are an attorney, you may want to represent clients and they have dealings to the town. They want to come for some permit or something like along those lines. If I'm on a zoning board and I'm an attorney, I'm not allowed to do that because I'd clearly be acting as an agent for a third person in something the town has an interest. And if I'm getting paid, that covers both of the forks there. If you're a special municipal employee, so using myself again, if I'm a special municipal employee on the zoning board and I want to represent a client before the school committee, that's okay because it's not a matter that the zoning board's ever going to have to deal with. But one thing I could never do is go sit on the other side of the table at a zoning board meeting and represent a client. That's simply not allowed under Section 17. And as I say, the first part of this, receiving compensation from anyone other than the town, this can have some tricky pieces to it. That's one reason I brought the acting as an agent handout, which is printed off the Ethics Commission website. And so if you are, let's say you own a business in town and you need to go to the town to get some kind of permit, Section 17 can get triggered if you're being paid by a private client with regard to whatever you need this permit for or whatever they need this permit for. Then you're being compensated by someone other than the town in a matter in which the town has an interest, and the Ethics Commission would say, well, if it requires some license or permit issued by the town, it's a matter the town has an interest in. Similarly, acting as an agent for someone, you in your professional capacity, you come seek this permit on behalf of a private client. You may be found to have just acted as an agent for that person. There are some specific exemptions for the kind of the building trades. If you're you have a construction company and you happen to work in the building office, for example, there's a particular, it makes it a little easier for someone to go get a building permit in that case, but it depends on the facts, as a lot of these things do. Acting as an agent, so that's the term in Section 17. It's not defined anywhere, but the Ethics Commission has over the years explained what they think that means, and it's not nearly as formal as you might think. Again, if someone's an attorney and they have a client and they're getting paid by them and they're representing them, maybe they're even representing them in court, certainly that's acting as an agent, but it can be a lot. It's pretty much any time that the municipal employee is acting on behalf of someone else, not themselves, in any kind of communication with the town office, trying to work through something they need from that town office, just acting as a liaison, trying to help out, a friend of yours who needs to deal with the town and you want to help them out, and so you do the talking. Filing documents with a town office, again, an engineer prepares a plan, puts their stamp on it, and it gets filed with the planning board. They've just acted as an agent for whoever needed that plan. And even serving as a spokesperson, you might be part of a neighborhood group who has a concern about some big project that's coming in. There's not a problem for you to be part of that neighborhood group and meet and talk and kind of list out your concerns that you want to bring to a selectmen's meeting. But you're best off if you let somebody else in that group do the talking that night, because even something as loose as that, you can be held to be acting as an agent for this group. So generally, anytime you need to interact with the town and it's on behalf of your employer, some other company, somebody else other than yourself, you should just keep these restrictions in the back of your mind. As I say, it's not triggered if you're not representing someone in front of a town board or office. And as I just say, you can kind of be behind the scenes and let somebody else be the face of whoever needs to interact with the town. This is one issue that came up enough that they created a special regulation about it. A lot of things like the libraries and the schools and what are some other ones. There are people who, really want to support them, and so sometimes you create a, nonprofit corporation on the side, or maybe it's just a group. You have Friends of the Public Library, Friends of the, Historic Town Hall, whatever it might be. A lot of times the people who are, that's their passion, they might end up also wanting to be on the Board of Library Trustees. So that can pose a problem as well, because in their Friends of the Library hat, if they contact the town, they're acting as an agent for that private group. It happened enough, so as I say, the Ethics Commission came up with this regulation saying, well, if the Board of Library Trustees wants to have a member sort of be their designated member in this group, then that's okay, and you don't violate Section 17, even though you may have some sort of wearing two hats going back and forth. So that helped out that problem a little bit. And you can always advocate for yourself. If you're a town official, town employee, you get your tax bill, and you want to try to get an abatement from the Board of Assessors, even if you are in the assessing department. If you are advocating for yourself to argue for that abatement, you're not acting as an agent for anyone else. You're just speaking on behalf of yourself. So that is always okay. Section 19, another one which comes up a lot, is it says whether you're appointed or elected, and it also doesn't matter if you're a special municipal employee or not. It applies the same. You can't participate in your official capacity in any particular matter in which you, your immediate family members, or your private business or employer has a financial interest. And the commission says this doesn't matter if it's $10 or $100,000, or if it's positive or negative financial interest, you're not allowed to participate if that's the case. So this poses a lot of problems, as you can imagine, especially in a fairly small town. Things are going to cross paths like that. If you're an appointed position, you're either a town employee or you're on a zoning board, conservation commission, all those ones that are appointed rather than elected. There is an exemption saying if you fill out a written disclosure of what your office is, what this matter is that's coming before your board, and you would like to participate, you think you can do so objectively, and you don't want to leave the board shorthanded, you can fill out that disclosure, give it to your appointing authority, and if they agree, they don't think it's a big deal, they don't think it's going to be a problem. If you participate in it, they can sign off at the bottom of that disclosure form, and then you can participate, just like this issue wasn't there. That does not apply to elected offices, so they are stuck if there's a financial interest that comes before them. Let me go back just for a sec, because the reason I had that handout about acting on matters affecting abutting property is the Ethics Commission a long time ago decided that if you sit on a board, particularly all these land use boards, zoning, planning, conservation, Board of Health, anything that is involved with property all the time, and something comes before them and you're in a abutter to that property, or you're in a abutter to an abutter within 300 feet, which comes from the Zoning Act, you live across the street, or for some reason there's something about this project, then you are close enough that it might affect your financial interest of your property. The Ethics Commission decided, well, it's so hard to make that call on a case-by-case basis, so if you are in a abutter, or an abutter to abutter within 300 feet, we're just going to deem that you do have a financial interest, and Section 19 prohibits you. And the only way to affirmatively refute that is to have a certified appraisal done, which says, no, regardless of what happens with this particular thing before the board, it's not going to affect your property at all. And of course, nobody's going to do that, especially if you're sitting on an unpaid board. So that, that's just something, again, this needs to be sort of a red flag if it comes before you. and it's right down the street, it's on your block or something, because Section 19 might kick in, and inadvertently, and there are a lot of inadvertent violations of the conflict law, particularly this one. So it's good to keep it in mind.
I have a question.
Oh, sure.
So on this section 19, as far as financial interest goes, there's going to be some place where you draw the line. I mean, let me just give you a hypothetical. Say I have a brother who owns a plumbing company, and he's a subcontractor, and he's putting in all the plumbing in all the houses in the development. And then that developer comes before the planning board, and I'm a member on the planning board, and he wants to expand the development to put more houses in. Obviously, it would be beneficial to my brother, the plumber, if the developer gets to put more houses in. So are you telling me that I have to recuse myself from anything involving that development because my brother happens to be a plumber?
Well, you're not going to like my answer, but no, that's a great question, and that's exactly what I mean about sort of things that don't even cross your mind, because I believe if somebody, let's say you start acting on that, and somebody made a complaint to the Ethics Commission, they start looking into it, I think they would say, well, if you knew when this proposal to expand the development came up, that it's either your brother was definitely going to get more work, or if it was reasonably foreseeable, that's the phrase they use, that he would have a financial interest because he's going to get more work.
That's somewhere where disclosure can be made?
If you're in an appointed position, you can go to your appointing authority and say, here's the facts. I would like to participate in the board's consideration of this because, we don't want to keep a full complement and this and that. As long as your appointing authority says, okay, I trust you're not going to be voting yes to give your brother more work, because I know you. And so they'll sign off, and then you're covered. Elected boards, like planning boards typically elected, it's kind of a tough result. But they're very strict on Section 19, I'm afraid. Yes, sir.
Isn't there an exemption, though, if you're on the board, and like a small town, you have problems getting quorums a lot of times, and can't he say that his brother's on it, they can't get a quorum? Isn't that an exception where he can get paid?
There is. It's called the rule of necessity. And the Ethics Commission, they're very strict in the way they read that too. But what it says, first of all, they would say it needs to be an elected board, because if you're appointed, you can do that exemption I just talked about, get your appointing authority to sign off, and then you're fine. If it is an elected board, and because of conflicts of interest, you don't even have a quorum, then you can invoke what's called the rule of necessity. Basically, you're supposed to disclose whatever your conflicts are and say, under the rule of necessity, these members who have a conflict can participate anyway. But again, it's supposed to only apply if the only reason you're lacking a quorum is because of conflicts. Like it's, let's say it's a 5-member board, 2 members have a conflict, and then you have a 5th member is vacant because somebody just resigned. Ethics Commission would say, well, you're lacking a quorum because you have a vacancy, not because you had a majority of the members with a conflict. So it's pretty narrow when you can use it, but sometimes you can. And you won't find that in the statute anywhere. It was created by a court decision, I think. So, but that is out there. Sometimes it helps. Section 20 is the most difficult one to read of all of them. It's very long. It does have lots of exemptions, which can help. What it starts out saying is that a municipal employee cannot have a financial interest in a contract with the town unless you qualify for one of the exemptions that's in there. And there's a lot of them. I'll touch on some of them at least. And contract can include a town office if it's paid. So if you have you serve on an unpaid board, and then a part-time position opens up, and you want to apply for it and keep the board position, Well, sometimes you can, but that's also considered a contract, and so you have to look and see what kind of exemption might apply. It's a little easier for special municipal employees. Sometimes all they have to do is file a disclosure and file it with the town clerk's office, explaining what this contract is. And it's not just another town paid position. Maybe you have a little business on the side and you want to get a contract to sell something to the school department. Well, that's obviously a contract with the town. If you're not a special municipal employee, you'll have to see which one of the exemptions might work. If you're a special municipal employee, you may be able to just file a written disclosure of this contract that you have just received and be covered. There's one that applies to part-time or call positions in police, fire, ambulance, that sort of thing. You need to get your appointing authority usually to sign off that there really is a need for this position. So certainly there's a good policy reason for making it a little easier for that. They say if you're getting a housing subsidy through some program with state money that the town is running, they don't consider that a contract. They say that's exempt. And let's see. Well, there are some other. If you're not a special municipal employee, a lot of times you're stuck with this one, which we just call the regular employee exemption. And it says, you can pick up a contract with the town if it's with a different department than the one that your main position is in. It's made after public notice, which might sometimes include public bidding, but at least it has to be, some sort of advertisement so the public knows that it's available as well. You file a written disclosure with the town clerk. If it is another position with the town, in other words, you're performing personal services for the town, it has to be outside of the normal hours of your first position. Can't pay for more than 500 hours a year, which is only about 9 hours a week. The head of the agency with this contract files a certification that, yes, we really need someone in this position, and the Board of Selectmen votes to approve it. So a lot of times you can get partway through this exemption and suddenly you trip over something.
Can you give an example of that? I'll look at that saying, okay, a full-time firefighter has an electrical business on the side, which happens all the time in the bigger cities. Is he then eligible to submit a bid to the town to do electrical work?
I would say so. He would, the contract, we'll try to work it through. The contract would be being awarded by somebody besides the fire department. If it was in the fire department, it wouldn't work. But assuming it's elsewhere, there's a public availability. Public notice is given. We've got this electrical service contract available. He would file a written disclosure. It would obviously be outside of his firefighter hours. If he wasn't going to be paid for more than 500 hours a year, it might be sort of a continuing contract, but very often it's still not going to be that much. Whoever the contracting authority is, files a certification, and the selectman votes to approve, in a public meeting. It's a good chance he could qualify for that. It's just a pain. Okay, these are some other ones which were used to pose even more problems, but the Ethics Commission did come up with some regulations which helped a little bit. One is, before this regulation came, let's say you had a paid position, full-time, part-time, either way, and there's a vacancy on the Conservation Commission, which is unpaid, and you'd like to volunteer to serve on it just because you want to help the town out. The way it used to work is, okay, you get appointed to the Conservation Commission, and that didn't create a contract because they don't get paid, but now you're on the Conservation Commission, you need an exemption to keep your paid office that you had first, which was kind of crazy and got in the way a lot. So now they've said that if you have a paid position, or unpaid, but if you have a town paid position and you accept a position which has no compensation at all, no salary or stipend, they're not going to make you look back the other way anymore. It does have to be in that order, however. If you're on an unpaid board and now you want to pick up a paid office, you're going to have to deal with Section 20. Again, this contract is pretty broad. It, it could be an actual position with the town. It could be selling some kind of product. As I say, engineers or other professions may want to get hired by the town. Those are all going to be contracts. It covers buying and selling real property as well. The only exemption which the Ethics Commission created by regulation was if someone who is a municipal employee has a piece of property and the town wants to buy it. Obviously, that's a contract with the town, but they understand that there's kind of no way for the town to be able to buy that and have this person, keep their town position. So that is not considered. That's sort of an exemption to the contract. It doesn't work the other way. If it's town property and a municipal employee wants to try to get it, you probably would be able to submit a bid for it if it's done that way under that regular employee exemption. But again, contract is a real broad brush, so you need to be aware of it. The last section I'll talk about, Section 23, it's kind of a catch-all. Ethics calls it the Code of Conduct. And so things that didn't pose problems under 17 through 20 might here. And so the two that come up most of the time, there are some which are real specific and just don't come up very often. But Section 23B2 says a municipal employee cannot use or attempt to use one's public office to obtain for yourself or others any unwarranted privilege of substantial value, which again is $50 or more, that's not properly available to similarly situated individuals. And so basically this boils down to improper use of your office, using inside information that the public, that you're going to take advantage of, that the public doesn't have, for personal gain, or to give a friend of yours a gain or something. That's what falls under 23B2. And the Ethics Commission, they have a lot of decisions out there of fining people for this improperly using your office. Let's see. I think I have some examples, maybe a separate slide. But, it can even be things like, as kind of silly as it sounds, if you're on the Board of Selectmen and you get pulled over by a town police officer, you say, you can't write me a ticket, I'm on the Board of Selectmen. Don't you know who, reviews your performance each year? Even just doing that, that's literally a case that the Ethics Commission had, and they fined that person for attempting to use their office to, gain an advantage that nobody else who got pulled over would have been able to even try. And then 23B3, we call the appearance section. So what it says is that a municipal employee, again, doesn't matter if you're special or not, applies to everybody, may not act in a manner which would cause a reasonable person having knowledge of the relevant circumstances to conclude that you're acting with bias, favoritism, or otherwise for personal reasons. And so this one, you can trip over because in your own mind you might think, I'm being totally objective. This isn't a problem. But if somebody else, seeing that you're, sitting on this hearing, might think that you're going to act with favoritism, conceivably, you could violate this section. However, it also provides that in order to avoid a violation, before you do that action, you fill out a written disclosure, file it with either your appointing authority or the town clerk, and that way you're protected. And so an example of that is, as I said, you're on a board, your brother, your father, somebody comes in and is applying for a permit, so you need to deal with that. Section 19 would say you're out because they have a financial interest in it, and you need to recuse yourself. However, if it's just one of your best friends, you've been friends for 20 years, and it's known around town that you do things together, conceivably somebody seeing you sitting on that application would say, well, of course he's going to vote in favor of, that guy. It's one of his best friends. Just to cover yourself, if it even kind of crosses your mind, I wonder if anybody would think that I'm not going to do the right thing here. I'm always telling people conservative advice is, the fact that it even crosses your mind, why not just fill out this written disclosure? It doesn't have to be fancy. It can be a sentence or two. File it with your appointing authority. And that way, if somebody complains after the fact, you're actually covered under this section because you filed the disclosure.
Ron, couldn't you argue, how tight of an argument does it have to be in a small town like this where, the Board of Selectmen and certainly one of them is going to have a business in town, or any other appointed board official. Can't you argue that in general, positive decisions made on behalf of the community are going to have a positive financial benefit to the person involved on it? I mean, how specific does it have to be? If I sit on the zoning board and I'm rezoning something, I own a piece of property in a quarter of a section of town, do I have to use myself on it if I stand to benefit? That's a good example. That's actually falls under section 19, which is don't act on something in which you have a financial interest, right? So one of the exemptions under that statute is if it's a matter of general concern and applies to a substantial segment of the population, which ethics has said 10%. So just as an example, members of the Board of Selectmen probably typically own a piece of property in town. So every year they have to set the tax rate, which is going to make little variations on their own tax bills. Do they have a financial interest in that? Well, of course they do. But it's actually the same financial interest that every other property owner in town has. And so the analysis of that would be, okay, that's not sort of an isolated situation. It applies very generally. So that's not going to be a violation. Other than that, I think, whatever comes before you to act on, you just need to kind of think about this and say, would a reasonable person, knowing all the facts, think that I'm going to act improperly here? It may be that, it's too much of a stretch and somebody complains and, even the Ethics Commission agrees, no, that was an unreasonable, I want to throw more hypotheticals at you, but I don't want to piss anybody off.
Okay.
But I can just tell you the scenarios could be endless.
They could. When I talk to people, when they have a question about it, sometimes I think, okay, you described that to me, and that just seems too far-fetched that the Ethics Commission would agree that it really looks like you didn't do your job. You know what I mean? It's more than just, there's got to be sort of a reality to it too. Not only did you participate in this, but you clearly voted the opposite of what you probably should have. So it's usually you don't see a lot of violations of this section, frankly. In the back?
If you're a building inspector, and say you're issuing a building permit or inspecting something, and say you're doing it for one of the selectmen or the appointing authority or anybody, should a disclosure be written? Is that okay?
I would say so. If you have any kind of position, maybe less so if it's the zoning board or something, which obviously don't get paid. But in that kind of case, a building inspector who has to come sign off on something in a selectman's house. I would say if they do that, there's no other section that's triggered, so it's not really a problem. But I would say better safe than sorry. Fill out a disclosure. I have to sign off on this addition at 12 Main Street. So-and-so who owns it is on the Board of Selectmen now, and file it.
If it's appointing authority, same deal?
You've got to sign off on a pellet stove that I put on in my house when we found a minister. So you should file a disclosure, correct?
I would say so,
Okay.
because
Only at appointment.
You never know, people are out there watching you. And, again, it's so easy to avoid violating this section. Fill out the disclosure, you can do it in 2 minutes. So I usually tell people, I think that's close enough. I would file the disclosure.
And that's part of that 268A or whatever it is, right?
It's this section 23B3, yeah.
Is this like the other disclosure that elected board members can't use this?
No, this one applies to all municipal employees. Yes, exactly.
All these written disclosures become public record.
They are public record.
And
I mean,
the way you presented it, it sounds like any kind of written disclosure is sufficient. But it seems to me that you might be disclosing something that in fact is in violation. But the fact that you filed the disclosure in itself doesn't eliminate the violation.
I mean, you're right. The disclosures are.
In other words, I think the language that I've heard, so far is, well, file a disclosure. But you might be disclosing something that's illegal or unethical.
Yeah, well, certainly the way this is designed to work is that you're filing a disclosure before you've done whatever might cause the problem.
Right.
You know what I mean? It's not.
You've done it before, it doesn't eliminate the possibility that there might still be something that's illegal or incorrect in some sense in what you're disclosing.
Well, there are cases such as, well, let's see.
I mean,
Yes,
is the filing, is the responsibility, let's say, the town clerk to review this disclosure and say, this doesn't make any sense, or this is wrong, or this is...
No, it's always on the individual. You know, you're the one, the individual's the one who's at risk of a violation, and it's up to them to do whatever might need to be done, whether it's.
There might be subsequent, at some point, there would be litigation, other things in that disclosure, potentially.
I mean, potentially. If somebody files a complaint with the Ethics Commission, which is done anonymously, you never find out who filed the complaint against you, they might look into it and say, well, okay, you filed the disclosure. Well, when did you file it? And, had you already done what you're not supposed to do before you filed it? Because typically they don't cure, after the fact. I mean, I think I see what your, question is, but, I mean, the best I can say is you see something that's coming and you think it might be a problem. If you're not sure which disclosure is correct or whether that's going to be enough, or do you actually have to, walk away from the table, you can get an opinion from town council's office, or I was going to mention it at the end, the Ethics Commission has an attorney of the day. They have legal staff, and you can call in and talk to them, and it's free, and they know their stuff, and so they can say, all you have to do is fill out this section 20B disclosure and file it, and you should be okay. Or, no, I'm afraid there's nothing you can do about that. You're just not going to be able to participate.
Is the point of disclosure that you're just trying to be transparent, that, I know that this appears to be a conflict?
Yeah.
I'm transparently going to make an inspection, no funny business,
Right.
You're welcome to, I'm disclosing it to you so you can scrutinize it to the degree that you want.
Yeah, that isn't it is just to be transparent, and these disclosures are public records. You don't have to sort of, tell the world that I'm filing this disclosure, but you do have to file it with the right party. And if anybody said, I'd like to see the disclosures that were filed last year, they are public records.
Okay.
Yeah. Yes, sir.
If somebody has a concern or a question and they want to seek legal counsel, they should not call counsel personally themselves. Would that be done through the administrator or the board of selectmen? Otherwise, you might have 10 people calling for legal advice on their...
No, that's correct. You would need to go through the administrator's office if you want something from us. But again, the Ethics Commission, you can call and run your fact pattern past them, and the attorney there will say, no, I think you're fine, or just do this and then you're fine. And that's really, that's kind of the best way to do it. I just got a couple of formal advisories that the Ethics Commission put out that I'll mention at the end here. This one came out in 2012, having to do with fundraising. Most town departments that don't really get engaged in fundraising, but again, I don't want to pick on the library, but a lot of times the library will do that, or police department want to try to get donations to buy new equipment or something, and it's not illegal right off the bat, but you have to be careful how you do it. Any donated funds that come to the town have to get handled through this gift account, goes through the treasurer's office, and you can't use either overt pressure or kind of inherently pressure on anyone you're asking for. And just as an example, if you're just hypothetically, the fire department is trying to raise money to do something, and you go to a business that has to get inspected by the fire department every year. You don't want that business to say, oh, maybe if I don't donate, I might be giving myself a problem next month when the inspection's due. That's the sort of, implied pressure. So, if you're ever involved in it, and again, not everybody does, just be aware that you need to avoid being inherently coercive. Somebody who has a current application in front of the planning board and they're asked to make some kind of donation. Well, are they going to think, maybe this will improve my chances if I make it? That's to be avoided. Other things, improperly using your office, as I mentioned before, the 23B2, using town resources for personal business or personal purposes. Your office or your board may have a lot of information that knowing when some piece of property is going to come up to be available or whatever that might be. Using using town equipment, computers and whatnot to crank out some document for your private business. That's all considered improperly using town resources. Also directing subordinates to act on private interest. There's some cases for the Ethics Commission of someone telling the DPW driver, take the end of that load of road patch and go put it on my driveway. Things like that. Obviously, that's not good. And I mentioned the person getting pulled over by the police. Don't you know who I am? What are you doing? So I've talked a lot about the Ethics Commission. That's because they have total control of this. They're a very independent agency. The end of last week, they actually issued something saying they think the Secretary of State just violated the conflict law. So that'll be fun to see where that goes. Their website is actually pretty good. They have lots of different advisories. They have some that are particular to particular town offices, building department employees, conservation commissions, and so it's kind of a handy little guide. And I mentioned the attorney of the day. You can call in and leave your name and number, say what town you're with, and almost always they'll get back to you that same afternoon. So it's a very useful resource. Because as you can see, there's a lot of little tricky pieces to this law, unfortunately. And the Ethics Commission, if they think it's serious enough, or particularly if they think you did it even knowing it was improper, they're not afraid to have kind of a formal hearing and hand out fines. So you do want to be careful. Try to stay ahead of anything that could lead that way. That's all I have. I'll be around for a bit if anybody wants to ask me a question, but again, I appreciate your attention, and good luck avoiding the conflict of interest law. Thanks.